Oh, what a pleasure to be able to get at these three. Martin Flaherty, I don't know how long I've known your work, ever since coming up. I'll yield the floor.
Thanks for jumping in at the wrong time. Good afternoon, everyone. Welcome back. It's my pleasure to be here in my official capacity as facilitator of this panel. My name is Anna Spain. I'm on the faculty here, and I specialize in international law and national security. And it's just such a special moment to appreciate the work of our dear colleague, Professor Brough. Now, Hal's work is inspired, in part because he himself is inspiring. He understands the importance of vision in leadership and in law. And so I wanted to, as a way of introducing our panelists and what we're doing with this panel, talk about his aptly titled Chapter 13, The Vision Thing. So in this chapter, Professor Brough raises the choices a president makes through the lens of how the president views both the world and his role in shaping the future. And so we get to see through President George H.W. Bush and also through President Clinton their response and reaction to crises and geopolitical constraints of the time. And so one of the ways that we understand the role that the Constitution has in shaping choices presidents make, as our panelists this morning talked about so well, is through what's happening in the rest of the world. So this afternoon we turn a new lens to consider these same themes as we look at a comparative view. And so I'm pleased to introduce these three colleagues and scholars and professors who will do just that. So our first panel presentation this afternoon is a collaborative effort between Professors Gabrielle Appleby and her colleague, sorry, I'm blinking here, it's horrible, Dr. Adam Webster. And they've written a very important paper that responds to a 2014 article that Professor Brough wrote in the Adelaide Law Review, that it talked about the role of U.S. executive authority and its implications for and on the Australian government. And so they're going to be responding to some of the prompts that he raised in that piece, and giving us, in doing so, a way of understanding ourselves from the outside. My third colleague this morning is Professor Martin Flaherty, who comes to us from the Woodrow Wilson School, where he's a visiting professor. He's also more permanently based at Fordham Law School. And he writes about the intersection between what we like to think about in law and the real politic of how it works in the larger realm. And so a lot of his work has questioned some of the core assumptions we have about whether or if law works. And so he's going to be, I believe, talking today a little bit about the Supreme Court's understanding of its role, its jurisprudence in foreign affairs, and his own view about the appropriate role for the Supreme Court in that regard. Each panelist has 20 minutes or so, and we will aim to leave 30 minutes for questions and dialogue and discussion. Thank you. Please join me in welcoming the panelists.
Greetings. We panelists between ourselves just called what in American football, I'm not sure in Australian rules football, would be called an audible. So we decided that I should go first, since I'll be talking more about U.S. constitutional law issues, and then they will be talking about the Australian side. So first of all, thanks to everyone for coming. Thank you to the law school. Thanks to the Law Review for putting this on. And sticking with the Colorado theme, I wanted to mention just a few give a few other shout outs. One is I couldn't neglect the opportunity, since this is sponsored in part by the Byron White Center, to, having worked for Justice White, acknowledged him and the fine way that the center is carrying on his legacy. Beyond that, especially since Hal has been using baseball signals, permit me to tell one quick Byron White story, which I don't think people generally know about. As many of you do know, he was a great athlete before he became a Supreme Court justice. He finished first in his class at Yale Law School while during the fall leading the NFL in rushing 2 seasons. He was also a fantastic basketball player. And so a bunch of us were having lunch with him and we said, well, Justice, we know you were a great football player, we know you were a great basketball player, but what about baseball? You know, a number of us are baseball fans and, you know, I think it was around the World Series. And he said, with a twinkle in his eye, not one sense of conceit, just, he really meant this to be humble, he said, yeah, I played baseball at Colorado. I wasn't good enough to make the pros, pause, but I did hit 405. We were just. The other shout out I want to give is to, actually, Ira Rothgerber, and to his memory. I never had the privilege to meet him, but I know Justice White always spoke with him, about him in just glowing terms as one of his dear friends. And so since this conference is named after him, I think he should be acknowledged. And last and hardly least is our honoree here today. I won't say much about my views concerning the book. I will say that if you, and I think it'll become evident in my remarks anyway, but if you care to see them, I have both, in the spirit of this morning, secret remarks and public remarks concerning this book. So the secret remarks were when I got the manuscript draft from the publisher and they wanted to know whether it should be published. And after hemming and hawing, I eventually said, yeah, it needs a little work, but yeah, go ahead. No, I said, look, you have to publish this. This is fantastic. And I took some of those remarks, or some of those comments as a basis to write a book review in the Case Western Review, which was intended as a rave. I hope it was taken as such, because I really think for many of the reasons said today, it is a critical work and critical contribution to separation of powers, both analysis and history. Okay, and so I hope the fact that I've given Hal a rave review publicly will at least prompt him to forgive me for the rest of my remarks. Not that I'm going to say anything bad, it's really more, I want to talk mainly about a book project that I'm working on, and this is going to fall into the sort of category that I'm going to prattle on about my own book, and then at the end, if I have time, say how Hal's book relates to what I'm working on. It's kind of in the category, you know, but enough about me, what do you think about, you know? So let me get to it. My project is, as Anna said, about the judiciary and foreign affairs. And my essential thesis is that the executive over time has been displacing both Congress and the court. I want to really focus on the court's role through many of the processes that Hal describes in his book, and some of which he talks about specifically. But I also want to argue, bringing a bit of normative and legal bite to the analysis, that is actually a bad thing, not a good thing, as it's been happening over the past 200 years. So the roadmap is essentially, I'm going to talk about the aspects of the project I'm working on, which will include a little something about modern doctrine in foreign relations with regard to the court's conception of its role. And then go back and look at what the original understanding or understandings were of the judicial role in foreign relations. Then look very briefly at 200 years of intervening custom, for which I will say a CEG, you know, just C, cite to Hal. And then talk a little bit about how international relations theory, modern international relations theory, exacerbates the problem of the court's receding role in foreign relations. And then I want to relate this to Hal's work, which I think is going to be critical to my project as I go through. So let me start. First, a snapshot of modern doctrine. The modern doctrine, first of all, the question of what the Supreme Court's proper role is in cases that either implicate foreign relations, which is more and more in a globalized world, or international law, cuts across several areas of doctrine. And one thing I want to argue and one thing I want to note is that in many ways the Supreme Court today is at the crossroads with regard to whether it should play a robust or modest role. What are some of those doctrinal areas? I was talking to Peter Shane earlier today. One is, are treaties self-executing or not? In the Medellin case, the Supreme Court may or may not have reversed the ordinary presumption that treaties are self-executing. And if treaties are not self-executing, that means courts in the United States don't get to apply them as the supreme law of the land. In a non-constitutional setting, the Alien Tort Statute. In the second Kiobel case, the Supreme Court applied a very wooden conception of the extraterritoriality doctrine to essentially eviscerate traditional, or potentially eviscerate traditional ATS doctrine, and again, diminish the court's role, which had been built up for over 30 years. Another, treaty termination. Kurt Bradley, formerly of this law school, has written a very fine article on this. This still remains an open question in constitutional law, although it may well have been settled through some of the processes we've talked about. There's no treaty termination clause. I usually tell my students, by the way, that the Constitution is kind of like eHarmony. This gets to what Hank said about text, that it's very good about giving you guidance in terms of getting into relationships, not so good about getting out. So there's an appointments clause, and there's no removal clause. There's a treaty clause, there's no treaty termination clause. And so, you know, the president and the courts, the president and Congress have fought over the termination power. And in Goldwater versus Carter, the court famously used various justiciability and political question doctrines to duck what I would argue would be undertaking its constitutional duty to say what the law is in this area. And then one that I mentioned this morning, and one that I've written about a little outside of this project, is judicial deference to the executive branch's interpretations of treaties, including treaties that impinge upon individual rights. In all these areas, I want to argue the court formally had been much more robust in asserting a role, and now it very much is at a crossroads. The court is divided, scholarship is divided. In fact, I dare say most scholarship in this area in foreign relations argues for deference to the executive branch due to institutional capacity and other factors. And what I want to do is push back against that happening on a number of grounds. And essentially my argument is this. One is I want to say that the original understanding contemplated a much more robust role for the courts in foreign relations. That's the first part of the argument. Second, that intervening custom, this is where some of Hal's work is critical, has demonstrated an accretion to the executive branch. But, and this is where the theory part gets in, depending on what I think any colorable theory of the role of custom should be in ripening, has not yet ripened to the point where the court should be, should take themselves out of foreign relations and international law cases. And then the most complicated part is to argue how recent international relations theory uncovers still further factors that comparatively empower the executive branch with regard to the other branches, including the courts. Okay, so we'll see if I can get through all of that. I'll just give you highlights of these arguments as I go through. So one, the founding and original understanding. Now, I, as much as anyone, am skeptical of arguments that reduce the founders thought X, the founders thought Y. That said, there are certain areas where you could say that both in general and on specific things, the founders did have at least a dominant view on certain aspects of how the Constitution should work. And one of those was that, generally the founders were internationalists when it came to how they believed both the courts should operate in foreign relations cases and how the court should apply international law. The most famous example here is what led to the Supremacy Clause and the whole doctrine of self-execution. One of the most important reasons for the Constitutional Convention was the fact that the United States was not living up to its treaty obligations. It couldn't, because Congress could make treaties under the Articles of Confederation and did, but it could not enforce those treaties through laws because it didn't have the power to pass laws. Who did? The states, and all Congress could do fairly impotently was ask the states to enact laws that would put the United States in compliance with our treaty obligations. What was the most important one? There were several, but the most important one was the treaty that actually gave birth to the United States, the Treaty of Paris of 1783. Articles 4 and 6 of that treaty protected the rights of British creditors and the rights of loyalists whose land had been dispossessed during the Revolution. Those were two key points that the British insisted on before granting independence or recognizing independence to the United States. Neither of those were upheld by the state legislatures. Would not pass laws making good those commitments. Former Tories and British creditors were not exactly popular among state legislatures. So what happened? What happened was, among other things, that gave the British an opportunity to keep forts along the Ohio Valley and was a recipe for further conflict as American settlers poured into the Northwest. So that foreign relations problem, among several others, were one of the key reasons why there was a push for constitutional reform to begin with. And as I say, the result was, at least in this instance, not just giving Congress the power to implement treaties, but making them automatically enforceable. As an international lawyer would say, making the United States effectively a monist state in international law, and who would enforce the law, the courts, as they did, and did robustly. Now, I would have a lot more to say about that, but that's kind of my quick soundbite example as an example of the founding commitment to a judicial role in foreign relations. Just a couple of other associated things I would say would be, at the time, it's not exactly an accident that many of the justices in the Supreme Court were actually some of the nation's foremost diplomats, starting with John Jay. Let's not forget former Secretary of State John Marshall. In fact, he wasn't even former when he first became Chief Justice. And in sort of international relations theory, which I will get to much later, it's no surprise that weak states tend to find solace in international law. That is basically a truism in international relations, and we were a weak state caught between warring superpowers for the first 20, 30 years of our existence. So, the Constitution contemplated, or at least the founders contemplated, a strong, robust role for courts, particularly in rights enforcement. One other soundbite I should give you is in treaty interpretation deference. The work of David Sloss indicates that of several cases, about 30, 40 cases that were brought in the early Republic in which treaty claims were made against the federal government, the Supreme Court accorded the executive branch's view and interpretation of the treaty zero deference, in striking contrast to what seems to be the dominant scholarly view today. All right, well, what happens, as George Herring's book, the title of his book indicates, when we go from colony to superpower, or early state to superpower? Well, it's much of what Hal describes globally in the sense of domestic and foreign relations powers. The executive branch gets much stronger. And to telegraph, and then, by the way, this is the part of my own book that I don't want to write. I don't want to write 200 years of stuff, in the space of 100 or 150 pages. So I'm thinking of doing what, Hart and Sachs did instead of having, just say, see how bruh, and then move on. But, for many of the dynamics that Heidi and many others talked about today, the executive branch has gotten much stronger over time, particularly in foreign relations, where it has even further built-in advantages when it comes to doing battles with both Congress and the courts. I referred earlier to Kurt Bradley's work on treaty termination. He provides a 200-year, thank goodness for me, he provides a 200-year account of how initially in treaty interpretation, either the Senate or the Congress almost always inserted itself into whenever the president attempted to terminate a treaty. And it was only as the more power accreted to the executive branch as a function of the United States becoming a power, a superpower hegemon, that more and more arguments of this president, that the president's made more and more arguments about the exclusive power to terminate treaties, and that those arguments started to become more and more successful, e.g. Goldwater versus Carter. So that's one example. Another example, and this is one article where I've written at least on about 100 years of custom, is the idea of treaty deference. Early on, as I said, David Sloss's work showed that the early Supreme Court and the early federal judiciary accorded zero deference to executive branch interpretations of treaty. That started to change in the late 19th century as the United States starts feeling its muscles as at least a hemispheric power. And those arguments that the executive branch's interpretations of treaties should be given great weight by the judiciary become more frequent and more insistent over time. Now, even today, that's an example of where I'd say we are still at the crossroads. I could point to you cases where the court will cite the need to give the executive branch great weight in its interpretation of treaties, but there are other important cases where it does not. Hamdan is one in particular, where the court out of hand rejects the idiosyncratic interpretation that the executive branch, i.e. John Yoo, gave to the Geneva Conventions. So we have moved to an area where the executive branch is threatening to push the courts out of the picture, contrary to the founding vision and the founding commitment to a balance among the branches in terms of separation of powers. That's bad enough as far as I'm concerned, but as quickly as I can, let me tell you how modern international relations theory makes the picture even more bleak. And it makes the picture even more bleak in the following way. What it says is that the way international relations works today, and this is the work of people like John Nye, Bob Cohane, Anne-Marie Slaughter, that we live in a world of disaggregated states where sovereignty has eroded. And the way nation states interact is less nation state, but the executive branch regulators and executive branch officials doing what we in New York would call schmoozing with one another back and forth. And also judges, judicial globalization, going to conferences, giving judicial shout outs to one another in opinions, and also legislators from various countries mixing. Now, what is the net result of all of this? This is something that the IR folks don't ask, but that I ask as someone who is worried about separation of powers and at least a rough balance of the branches. And my take on this is that the net winner clearly is the executive branch when it comes to this new form of global interaction. Interestingly, I think a distant second is actually the judiciary. And that, not even worth mentioning, largely due to collective action problems, is legislatures. But the bottom line is this is another factor among the many others that Hal talks about, where particularly in international relations, the role and weight of the executive branch is much stronger comparatively than either the courts or Congress, which places much more pressure on the founding commitment to separation of powers. So, this raises what for me is a critical aspect of really the whole day's discussion so far. Because in some ways what I want to argue is going to rise or fall based on what a lot of the discussion today is centered on. So, now let me get to Hal's book very quickly. His description of the dynamics of executive branch accretion, notwithstanding, the occasional defeats the executive branch has, I think, are incredibly useful. And then when I get to the portion of the book that I don't want to write, I am going to borrow liberally and cite even more liberally from Hal's work. So on the descriptive side, this is, as I say, an incredibly valuable work. It's on the normative side that I'm having problems, as I think everyone is. I think Heidi and others, David had mentioned that the notion of when custom ceases to become, constitutional custom of the sort of Frankfurter type, ceases to become a divergence from constitutional law and ripens into constitutional law itself. When does the gloss actually really become a gloss on the Constitution? Is a question that is tremendously under-theorized, the notion that legal process gives us a window into that, I think, is a very useful first step. What I want to argue, and what my inclinations are, is that for all that the executive branch has, tried to push the courts out of the picture, that custom has yet to ripen into legitimate constitutional law, especially given the quite salient commitments from the founding and the structural commitments of separation of powers. What I'm struggling with myself is how to delegitimize, if you will, this story of custom, such that we really are at a crossroads. We are not at a point yet where the executive branch can claim victory. And if we remain at a crossroads, what I want to do, using Hal's work, is to push things back to what I think are a normatively much more attractive position, which is that the courts should, as originally envisioned, be a useful and critical check on executive branch overreach, particularly with regard to individual rights in the realm of foreign relations and international law.
Well, can I first thank Professor Hart, the White Center, CU Law School, and the Colorado Law Review for having us all the way from Australia. And could I thank Professor Bruff? I met Hal in 2012 when I was here visiting the CU Law School, and since then he's been a wonderful mentor and a good friend. I've always had the opportunity to draw upon his wisdom and advice, and this week catching up with you, Hal, has been wonderful. I'm slightly fearful there's going to be a bill in the mail when I get home for some of that advice, but the check will be in the mail back to you. In 2014, in an article published in the Adelaide Law Review, Professor Bruff explained the executive power of the United States to the Australian audience. Professor Bruff described the constitutions of Australia and the United States as cousins. They share some traits, such as federalism, but in other areas there is less of a resemblance. The Australian system of government blends features of the federal system of the United States with the parliamentary system of the United Kingdom. The framers of the Australian Constitution were familiar with the US Constitution, both through their readings, particularly Lord Bryce's The American Commonwealth, and through their personal experience. Professor Bruff considered in his 2014 article how the modern American experience might assist in Australia's understanding of its executive power, particularly at a time when Australia's government appears to be increasingly relying on inherent extra statutory sources for the basis for its actions. Since Professor Bruff's article, there have been a number of further instances when the High Court of Australia has had to consider the scope of executive power. So it's against that background of such developments, our paper provides a brief explanation of American executive power, drawing upon Professor Bruff's American analysis, and offers a comparison of the two systems. I'll firstly briefly set out Hal's US-American comparison before turning to explain responsible government in Australia and the way it's been incorporated into the Australian Constitution. And then I'll hand over to Professor Appleby, who will describe how executive power plays out in practice in Australia, explain aspects of the inherent executive power in Australia, and finally examine the court's role in defining the limits of that power. At first blush, the most obvious transplants from the US Constitution to the Australian text are the vertical distribution of powers between the central government, which in Australia is referred to as the Commonwealth Government, and the state governments. And secondly, the horizontal separation of powers between the three branches of government. The structure of the three chapters of the Australian Constitution, the first three chapters of the Australian Constitution, the legislature, the executive and the judiciary, resemble the first three articles of the US Constitution. However, despite some similarities in structure and wording, there is one major difference between chapters 1 and 2 of the Australian Constitution and articles 1 and 2 of the US Constitution. And that is the principle, perhaps more accurately described as the practice of responsible government. Australia's head of state, the Governor-General, with only some exceptions, acts on the advice of his or her ministers and not as an autonomous government player. Ministers must sit in one of the houses of Parliament and are said to be responsible to it. This is obviously in direct contrast to the incompatibility clause in Article 1, Section 6 of the US Constitution. The Australian system of government, therefore, does not have a directly representative executive, and to borrow a title from one of Professor Bruff's books, there's no balancing of forces between the legislature and the executive as there is in the United States. To keep the executive in check in Australia, our system relies upon the proper functioning of the conventions of responsible government. Under these conventions, ministers are accountable to Parliament through mechanisms such as question time, in which ministers must respond to questions from members of Parliament, and the investigations undertaken by parliamentary committees, which have the power to require the production of documents and summon witnesses. While these mechanisms have provided a level of accountability between the executive and Parliament in theory, this is not always borne out in practice, as Gabrielle will explain. The theory of responsible government has been seriously undermined by the evolution of the two-party dominated political system, which you'll all be familiar with, and the growth of the size and complexity of the modern administrative state. Australian political parties are dominated by two major parties. On the one hand, there is the Conservative Party, called the Liberal Party, capital L Liberal, so I suppose that's the similar in some senses to the Republicans, if we were to try and draw an analogy. And they're in a formal coalition with a smaller party called the National Party, which largely represents rural areas and farmers. So that's on the one hand. On the other hand, we have the Labor Party, similar in some senses to the British Labor Party, who is perhaps more like the Democratic Party here in the United States. As in other parliamentary democracies, there is a necessity of maintaining the confidence of the lower house. As in other parliamentary democracies, the necessity of maintaining the confidence of the lower house has driven the development of strong party discipline in these parties, very similar to the UK, perhaps even a stronger discipline in Australia. In recognition of the failure of parliamentary accountability in the 1970s and 1980s, the federal government instigated a series of inquiries into strengthening of judicial review and the introduction of non-judicial accountability mechanisms, and included the introduction of merits review tribunals, an ombudsman, and a freedom of information regime. This led to the introduction of what has been known in Australia as the new administrative law. There has continued to be a concerning lack of parliamentary oversight around the exercise of executive power, particularly in the areas of delegated legislation and executive spending, both of which Gabrielle will briefly touch on later. In relation to Parliament's failure to supervise executive spending in Australia, courts have recently stepped into the vacuum to play an important role in executive oversight. Professor Bruff explains that this role for the courts might be met with some concern by the American legal scholar. In his 2014 article, he wrote, "The Australian system of responsible government does not include the American check of the separation of legislative and executive power with all its attendant jealousies. That leaves the courts as the constraining institution with the difficult duty of defining what is meant to maintain the Constitution. To an American, this seems to place a great pressure on the judiciary to decide questions it may feel unsuited to resolve." In this paper, we seek to allay Professor Bruff's concerns relating to judicial oversight of the executive as it is manifested and continue to expand in the Australian context. In 2014, Professor Stephen Gordbaum argued that the undermining of faith in political accountability mechanisms has lowered the historical resistance to judicial power. In Australia, we have seen the courts adopt an innovative response to this failing faith of political accountability. It has been the Australian experience that the courts have had an important role to play in our constitutional system that assumes the robust practice of responsible government. They have done so in prodding the Parliament to play a larger role in controlling and scrutinising executive power. So I now want to turn to briefly consider responsible government and the Australian Constitution in a little more detail. As Professor Bruff notes in Untrodden Ground, at the time the United States adopted its constitution, responsible government had not developed in the United Kingdom. The US framers were wary of executive ministers also being within Parliament for fear of corruption of the legislative process. As Professor Bruff explains in his book, English kings had developed a technique that jeopardised legislative independence. They corrupted Parliament by granting lucrative offices to its members in a successful effort to sway their loyalties and maximise power. However, as Professor Brough also notes, the British experience actually had the reverse effect. Holding offices in both the executive and the legislature would allow the development of parliamentary control of the ministry. The American framers did not have the benefit of seeing the evolution of the UK experience. In contrast, the framers of the Australian Constitution had the benefit of reflecting upon the American experience, as well as seeing responsible government play out in the UK and then later in the Australian colonies. Writing in 1901, John Quick and Robert Garran, the two authors of the leading commentary on the Australian Constitution at the time of Federation, described the gradual transfer of the executive power from the sovereign to responsible ministers as one of the most remarkable and interesting revolutions recorded in the history of England. Indeed, throughout the 19th century, the Australian colonists had fought with the UK Parliament to be granted the twin institutions of representative and responsible government. And it was not until the mid-1850s when the majority of the Australian colonies were finally empowered to draft their own constitutional documents that this was in fact achieved. These institutions were believed to bring autonomy and freedom, and it was thought that these institutions would be the check the previous autocratic powers would bring a check on the previously autocratic powers of the colonial governors. The question for the Australian framers then was whether Australia should retain the system of responsible government, which to date had served it well, or whether it should adopt the American approach and separate the executive from the legislature. There was very little support in Australia during the drafting conventions for a US-style presidential executive. In the Australian debates, nationalists were worried that an elected Senate with equal powers to the House of Representatives, particularly over money bills, would have the political power to grind the central government to a halt. The Federalists believed that the Senate would be an important part, would form an important part of the state's powers to oversee and limit the central government, which was of particular concern for the smaller colonies. After much debate, the Australian framers adopted Section 53 of the Australian Constitution as a compromise between these two positions. So Section 53 provides that the Senate has equal powers to the House of Representatives, except in relation to money bills. Appropriation and taxation bills cannot originate or be amended in the Australian Senate. So ultimately, the Australian framers adopted a system of representative and responsible government as the best way of restraining government power. Under the Australian Constitution, the legislature is elected by the people and is therefore representative. Today, there are 150 seats in the Australian House of Representatives, with the electoral districts being of about the same size. The Senate is made up of 76 members, 12 from each of the 6 states, and 2 from each of the mainland territories, the Australian Capital Territory and the Northern Territory. Members of the House of Representatives are elected for a period of 3 years, and senators are elected for a period of 6 years, with a half-Senate election occurring every 3 years. The ministers of the executive government will be members of the federal parliament and will usually be from the political party that holds the majority in the House of Representatives, and the Prime Minister will be the leader of that political party. In the Australian Constitution, the Queen appoints the Governor-General on the advice of the Prime Minister. And while the Queen has the power to disallow any act of the Commonwealth Parliament, that power has never been used. While the executive power of the federal government is vested in the Queen and exercised by the Governor-General, in practical terms, it's really the Prime Minister and the ministers who hold that power. While not expressly stated within the Australian Constitution, the unwritten convention is that the Governor-General acts on the advice of those government ministers. This is obviously the very backbone of responsible government. So Section 62 of the Australian Constitution establishes a body called the Federal Executive Council, which advises the Governor-General. Section 63 states, where reference is made in the Constitution to the Governor-General in Council, it shall be construed as referring to the Governor-General acting on the advice of that Federal Executive Council. So all ministers are sworn in as members of that Federal Executive Council. While the formal mechanism for providing advice to the Governor-General is through the Executive Council, it really is in practice cabinet, comprising of those senior government ministers, that makes the key government decisions and advises the Governor-General. The current cabinet, under our new Prime Minister Malcolm Turnbull, consists of 20 members, although this number has varied between governments. There is no fixed number as to the number of ministers. So now that I've set out sort of the basic workings of representative and responsible government in Australia, I'll hand over to Professor Appleby, who in the second part of the paper will address how executive power plays out in practice. She will explain the aspects of the inherent executive power in Australia and the court's role in defining the limits of executive power.
Thank you for setting my part of the paper up so well, Adam. And because I am rolling on from Adam's paper, I don't want to pause for too long, but I think it's necessary to pause just for a moment and to note my own personal professional debt to Hal, who's both a friend, colleague and mentor, and has been since my very first email to him as a cold call about 3 years ago to invite him to be part of a project with me, and it's been just a wonderful journey ever since, so thank you. So today in Australia, perhaps unsurprisingly, the Australian Constitution is practiced in very different ways from those imagined by the framers back in the 1890s. And this is not least with respect to executive power and the restraints upon the exercise of executive power through the conventions of responsible government. So one of the first assumptions that was almost immediately imploded was that the Senate was going to act as a state's house of review. Okay? Almost immediately in Australia, the Senate became, in effect, a second party house, and Adam's talked about the two-party system and the advent of party discipline. So what this has meant in practice is that our Senate provides party political review and not state-based review. So party political review, what does that mean? Well, at least since proportional representation was introduced into the Senate, which reduced the likelihood of the government having a majority in both the House and the Senate has been employed from time to time as a tool in party political stoushes. And I have been asked by Hal to translate that for an American audience. A stoush is an Australian colloquialism for a fight, and we particularly like to use the term when we're referring to political fights. So a stoush is usually a political fight. So in the most famous confrontation between the government and the Senate was in 1975, and the Liberal opposition leader, Malcolm Fraser, directed the Senate, which he controlled, not to pass the Labor Prime Minister, Gough Whitlam's, budget until certain political demands were met, certain releases of information were made, etc. Whitlam refused, very strong character, didn't like to go back, as we've heard with American presidents. And the failure of his government to be able to secure supply led to the first and the only removal of a democratically elected Prime Minister and his ministers by the Governor-General. This is pursuant to what we call in Australia the reserve powers, those powers that the Governor-General exercises, not on the advice of the ministers. But this is unusual. In contrast, what the party-dominated nature of the Senate has more often meant is that it's been reluctant to flex its muscle that it does have against the government. Parliamentary failure to hold the government to account is most frequently seen in politically sensitive areas such as national security and immigration, where there is often very little of substance distinguishing the positions between the two parties. So the opposition is very reluctant to be seen as soft by questioning the government's actions in national security and immigration. And further, as in any two-party system, there seems to be an institutional incentive built in not to provide an overly robust scrutiny of the government. Because whilst in opposition, a party can score political points from revealing maladministration and various other executive failings, the opposition is also very aware that it doesn't want to put in place processes and set precedents that make governing when it comes into office impossible or inefficient. So there's this institutional incentive to not provide too robust scrutiny. And in Australia, we see this played out in a number of areas. Delegated legislation is one area that I'm not going to talk about today, that I've written about in the past and happy to answer questions on. But I'll just quickly talk about where we've seen it in Senate committees and the reluctance of committees, even when they're not controlled by the government, they might have an opposition majority or be controlled by some of the minor parties. They're still really reluctant to exercise their powers against the government. And these includes the powers to summon witnesses and the production of documents. Even where they're protected by legal professional privilege, our courts have confirmed that the Parliament has the power to order those documents produced. But the Senate committees don't exercise these powers. So for example, in 2002, there was a Senate committee called the Senate Select Committee on a Certain Maritime Incident. You have to be Australian to know what that certain maritime incident was, so let me explain to you. The committee was established to investigate the so-called children overboard incident, which is still a little bit more Australian political jargon. What that was, it was an incident where it was alleged asylum seekers trying to reach Australia by boat had thrown their children overboard in an attempt to require the Navy to pick them up and take them to the Australian mainland. Once they were brought into the Australian territory, they got the protection of the Migration Act. But the claim was untrue. The pictures that were used by the government to substantiate this claim were actually pictures of children and asylum seekers in the water after their boat had completely disintegrated and they were being fished out of the water by Navy personnel, which is a very different story from the one that was being peddled by the government. Initially it was put forward by the Minister for Immigration, the Defence Minister repeated the claim, and eventually the Prime Minister, when asked about it on radio, said that the claim was true. So it kept on being reiterated. The Select Committee's terms of reference were to investigate how the story originated in the first place, that these children had been thrown overboard, when did the government know it to be untrue, and why it took so long for this to be publicly clarified. It was actually not publicly clarified until after the election, which had been in the lead up to. Now, the committee did issue summonses to the Defence Minister and to the ministerial staff, and also for documents to be provided, but they had real difficulty getting these people to appear and receiving the documents. The chair wrote in the report, and this is a quote, "Ultimately the executive, in the form of the cabinet, checked the inquiry's ability to examine relevant witnesses. This meant the executive was able to exercise its power to prevent full parliamentary scrutiny of itself. This is not open government." That's what the chair was saying. But the committee had the power to require the witnesses and the documents to be provided, but it chose not to do so. So while the US did not adopt the system of conventions that underpins responsible government, Hal has explained that it's still practice and convention that shapes the exercise of executive power in America. In the domestic sphere, and this is what he wrote in his 2014 article in the Adelaide Law Review explaining the American executive power to an Australian audience, he said, in the domestic sphere, the President is bound by Congress, and he refers to matters such as the funding of federal government and the appointment of judicial and executive officers. Rough contrasts this with the way in which presidents have developed conventions in the field of foreign policy and war making, which has basically meant that the President is unbound in this foreign policy sphere. This has resulted in a pragmatic but constitutionally less than desirable state of affairs, or a second best state of affairs, as the first panel was talking about, where in domestic policy, the presidents dance at the edge of existing statutes, and that's Hal's language, where action is nearly clearly authorised nor clearly forbidden. In foreign affairs, you have an equally constitutionally unsatisfactory position, where presidents exercise extraordinary war powers, largely in secret, with little participation from Congress. So Hal's conclusion in this 2014 article is that presidents are controlled either too much or they're controlled too little. And there's actually not much middle ground where the control seems about right. So in Australia then, the executive government is, as we heard from Adam, in theory, bounded in the domestic sphere by the parliamentary oversight and the conventions of responsible government. But in practice, has exercised its powers largely with impunity, even when it does not control the Senate. Or at least it's done so in the absence of a particularly nasty, looming political stoush. This is particularly problematic, of course, in a system that's premised on the accountability of the executive to the parliament, and as that's how our responsible government system is presumed to work. In the foreign policy sphere in Australia, the executive is subject to more scrutiny today than it had at Federation. But even then, it's light touch, and it's probably correct to say that the Australian executive remains unbounded in this sphere as well. Now, in Australia, in contrast to the US, this is largely a product of history. At Federation in 1901, Australia's foreign policy, including the entry into treaties and the power to declare war, was still largely undertaken by the British government. So these powers were not expressly conferred on a new federal government. They were not expressly divided between the government and the parliament. In fact, we would have to rely on the prerogatives that were incorporated into the executive power to find these powers later in our constitutional history. But what we've seen is that legislative scrutiny in foreign policy has actually eventuated. It's been late in coming, and the changes that have been introduced have been largely sort of toothless in their operation, but it's interesting to see that the executive has felt the pressure to put some accountability checks in place. In the treaty-making power, we see this most starkly. The executive, under our constitution, has a prerogative power to enter into and to ratify treaties with no involvement from the parliament whatsoever. That's the constitutional position. But a legislative change in the mid-1990s, introduced by a conservative coalition government, under that legislation, the executive's treaty-making power is now subject to scrutiny by a joint parliamentary committee who can make recommendations as to whether to ratify. They're non-binding recommendations. In practice, I think there's only been one or two occasions where the committee has not recommended ratification. So it's both toothless and has been very deferential to what the executive has done. Now in Australia, unlike the US, it's the executive and not the legislature that declares war, and that's the prerogative war-making power, and Parliament has no involvement. There has been some move in Australia, and some members, some MPs have argued increasingly loudly that the matter of declaring war and engaging in hostilities should be put before the Parliament, at least for debate, okay? At least for that first sort of a bit more transparency and openness. However, in Australia at the moment, this debate over whether we should have parliamentary debate or approval for war or the use of force has never looked like it would be seriously won because neither major party supports it. So all the proposals have been put forward by smaller parties like the Greens and individual MPs. However, what we have seen is in the UK a change in that position. And now it seems over a very short period of time, since 2003, quite a strong convention has developed whereby declarations of war and engagement in foreign hostilities will be put before the Parliament and debated. And if the Parliament does not approve that, the government won't go ahead with that. And we saw that in 2013 with the Syria invasion. Okay, so let's talk a little bit more about executive power in Australia. In his most recent work, Howe noted that Article 2 of the US Constitution exemplifies the principles of brevity and occasional obscurity. In the Australian Constitution, Section 61, which is the conferral of executive power, states with similar brevity and obscurity that the executive power of the Commonwealth is vested in the Queen and exercisable by the Governor-General as the Queen's representative. And the only definition that's given of executive power is that it extends to the maintenance of the Constitution and of the laws of the Commonwealth. And that's it. That's all we get in terms of guidance from the constitutional text. Now, despite the similarities between the Australian clause and the US clause, in Australia we presumed for decades, almost a century, that the executive power in Section 61 wasn't the same as the executive power in the US, but it mirrored the executive power of the British Crown. Okay, so because we're this Westminster mixture of systems, we thought our executive power, we went to the British Crown to find that. And it's really only been in the last decade that our High Court has said, no, actually, what Section 61 did was create something entirely new. Yes, it's informed by aspects of the British prerogative. That's where you get the war-making prerogative, for example. But it's also informed by the federal division of powers, which we got from the US. It's also informed by the constraints of responsible government and the need to be responsible to Parliament, again, going back to the UK. But then it's also informed by the evolving fact of Australia's nationhood, and this starts to come into inherent constitutional power, which I think we can learn a lot from the US about. So if we looked at, well, what is the scope of executive power today? Constitutional scholars would say there are definitely 4 sources of executive power. There are those powers expressly conferred by the Constitution. There are those powers expressly conferred by statute. There are the prerogative powers, and these are distributed between the federal and the state governments as is appropriate. And then there is this new inherent nationhood power. Now those sort of 4 powers probably look very similar to a US audience. There's also a 5th source of power, which we thought existed, but now we're not sure exists, and I'll come back to that in a moment. We used to call this the common law capacities, and as I said, the High Court has thrown some doubt on this in the last couple of years. In the full paper, we explain all these 4 types of power in more detail, but today I just want to talk about the nationhood power and the common law capacities, because it's these 2 aspects that intersect most directly with Hal's work and Hal's paper that he gave in Australia. So the nationhood power. This is the aspect of Australia's executive power over which constitutional scholars have exercised much consternation. So what do we mean when we talk about the nationhood power? The High Court has said that Section 61 of the Constitution includes the ability to engage in activities that are unique to the Commonwealth Government, that are necessary for the nation as a whole to function. Chief Justice French of the High Court has said, well, maybe it sounds a bit wishy-washy, but the precise scope of the nationhood power is unclear, and it must be an evolving concept, just as the kind of idea of nationhood is. So it's generally accepted that the nationhood power includes the power to respond to emergencies such as war and natural disasters. In the case of Pape, which was a 2009 case, the High Court upheld the Commonwealth Government's response to the global financial crisis in the forms of a tax bonus scheme, and that was upheld on the nationhood power, the emergency aspect of the nationhood power. It's been upheld to include dealing with symbols of nationhood, the passage of legislation to deal with the flag, the national anthem, that's the nationhood power. It's also been successfully invoked by the Commonwealth to pass legislation to celebrate Australia's bicentenary. So these are the types of things. Now, Australian constitutional scholars have been critical of the inherent nationhood power for 2 reasons. First, in terms of the reason the court has given us for creating the nationhood power, which is, well, someone has to have this power, and if it's not the Commonwealth, it would be the states, but these are things that you would prefer a Commonwealth government to do, or the Commonwealth government must do. Now that's been criticised because scholars say, well, there's the prerogative for these things. The prerogative would include the power to make legislation for a national flag, for example. So there's argument about the basis for the power. But then there's also argument about its lack of clear limits. Okay, and there's a lot of concern about lack of clear limits. Now, Hal came to Australia in 2014, and he attempted to comfort and placate us about these concerns. And he said, fear not. America has a long history with an inherent executive power. And in the United States, whilst there is much loose talk about an inherent executive power to do this, to do that, In fact, presidential actions can almost always be tied to some explicit grant of constitutional power, although the connection is somewhat tenuous at times. And this allows legislatures, courts and citizens to dispute the validity of these actions. Now, is that right in Australia? Can we take that comfort? What have we seen the Commonwealth do with this inherent executive power? Well, it's difficult. We don't really have a long enough constitutional history with this power to draw similar conclusions yet. What we can say is that, consistent with Howe's predictions, reliance upon the inherent power remains an argument of last resort. So, for example, in the second of the challenges to the national school chaplaincy programs, which I'll speak about in a little bit more in a moment, the Commonwealth was pointing first to its express power over corporations, then it was pointing to its power with respect to benefits to students, and only in the alternative was it relying upon this inherent power. More recently, there have been constitutional challenges to the Commonwealth's detention of refugees in offshore detention centres on Nauru and Papua New Guinea. And in these challenges, the government again first attempts to rely on a statutory power, even if it's a stretched interpretation of that statutory power, before resorting to the arguments that in fact it's a nationhood power that it's invoking. So perhaps the Australian government has been listening to Professor Shane on this point. Okay, so we've only had a couple of cases about the inherent power, and that's what we've seen so far, but I'd be reluctant to draw any conclusions yet. Turning then to this idea of the common law capacities, and this is where I'll finish the paper. One major difference between the US and the Australian constitutional provisions is that under the Australian Constitution, we don't have a freestanding federal executive spending power. Okay, so instead, we have to find the federal executive spending power somewhere in Section 61 of the Constitution. There is an express power in Section 96 of the Constitution, which is an express grants power from the federal government to the states. But other than that, we have to go to the Section 61 head of power. So for a long time, and I'm talking almost a century, it was assumed that Section 61 incorporated the common law capacities of the British Crown. Now these are the powers that the Crown enjoys in common with other legal persons. They include the power to contract, to spend, to give money away, to hold and dispose of property, to sue and be sued. Now in 2012, the High Court, in a case called Williams and the Commonwealth, cast serious doubt on this position. One of the arguments that have been put forward in defence of the existence of the common law capacities was that by their very nature, the fact that they're shared with other legal persons, they're non-coercive. You have to get the consent of the other side to enter into the contract to buy the property. And they're not peculiarly governmental, so we're not so concerned about them in that sense. But in Williams, the court said, no, when those capacities are exercised by the government, they take on a different character. The political and the financial strength of the government allows it to use those capacities to regulate behaviour and to achieve its policy objectives. So we should be more concerned about common law capacities when we attach them to a government polity. So what was Williams number 1 about? Williams was a challenge to the funding of the National School Chaplaincy Program, so school chaplains, chaplains in public schools funded by the federal government. The Commonwealth argued in that case that it was its common law capacity to spend that gave it its constitutional basis for that power, for that program, sorry. In a surprising move, a 4-judge majority of the High Court rejected the position that the Commonwealth Government enjoyed a common law capacity to spend. So that assumption for 100 years is thrown out the window. Instead, the court said that to spend, there must be some authority. It could be the nationhood power, it could be a statute, it could be the prerogatives, but there must be some other power. Now, a number of observations can be made regarding the High Court's decisions in Williams and what this means for the executive power in Australia. Hal has previously expressed concern, and Adam alluded to this in his paper, about greater judicial involvement in enforcing limits on executive power. He noted that to an American, this seems to place a great pressure on the judiciary to decide questions it may feel unsuited to resolve. So I think the first observation that can be made about the Williams decision and what the court did was the court was not enforcing substantive limits on the breadth of the executive's capacities, but rather it was insisting that such powers be authorised by Parliament before they're exercised. So what the court was doing in Williams was insisting on parliamentary processes that would strengthen the accountability of the executive to the Parliament. So it was intervening in the relationship between the executive and the Parliament, but only doing so to prod the Parliament to take a more active role in that relationship. The court's foray into this relationship between the legislature and the executive has received a mixed reception in Australia. There have been many that have lauded the decision from a democratic viewpoint. This is great, Parliament has to authorise executive spending, this is a good outcome. But Professor Jeff Lindell has expressed concern. He said that this may have come at a high practical cost in terms of government efficiency and the hardships created for those who contract with government, who might enter into a contract that subsequently is found not to have been authorised by statute or the nationhood power, for example. He expressed concern that the decision would leave the government hamstrung. So the second observation to make is that the Parliament has actually largely responded to the Williams decision by simply refusing to take the mantle that the court has thrust upon it. Parliament seems more alive to the practical difficulties that Lindell points out than interested in taking a greater role in scrutiny of executive spending. So what happened following the decision is that Parliament continued in its malaise about scrutiny of executive spending. The response was to introduce a new legislative provision that delegated Parliament's oversight of executive spending to the executive itself. So what the provision currently now requires is that the executive is authorised to enter into contracts and make grants and arrangements as are authorised in the regulations. And of course, who makes those regulations but the executive themselves. So this is Parliament's response to the court saying, you have to scrutinise spending more. So the third observation to make about the Williams decision is that the constitutional validity of the regulation authorising model is really less than certain. For example, there are arguments that the model amounts to an impermissible delegation of power. We have a pretty loose non-delegation doctrine, but there are limits set by the Federal Division of Power. So there are arguments that it's too broad a delegation. So what we've seen is that Parliament's lack of concern to ensure that its response to the court's decision was Parliament's lack of concern to ensure that its response to the court's decision was constitutionally valid, and to give the executive a largely free rein again in executive spending, has left both branches now dancing at the edge of constitutional certainty. So what we've seen in Australia is a failure of Parliament to take its scrutinising role seriously, and the desire of government to continue to govern efficiently, but not necessarily openly or transparency, is the adoption of a path that's not clearly valid, but not clearly forbidden either, which is where you found yourself in the US as well, but through a very different system. And I think I'll leave it there.
Well, thank you to all the panelists for your very intriguing comments that I think help illuminate this idea that understanding what a constitution can do comparatively is necessarily complex, and how Seminar, for his many students, have to engage in that project when they put together the US, the UK, and Australian constitutions in their papers. And one of the reasons it's complex is that it gives us opportunity and pause to challenge our assumptions about what a constitution is capable of doing. And we have a love-hate relationship because some of us want it to do more and some of us want it to do less. And we all want it to get to, as Professor Webster said, a responsible government. And so your comments looked at how can we do this, how can we understand the historical trends that lend us to the position we are today. And I think then turning to Professor Appleby's comments about understanding what is a responsible government and open government, not to mention the very powerful story of the government lying, which gets to my colleague Helen Norton's work. And if it is not an open government, how do we understand it in times of crisis where governments face the need for secrecy, the need to do things differently, which brings us to Professor Flaherty's upcoming book, looking at many of the cases that we've seen in the United States, particularly since September 11th, 2001, where in times of crisis, the government must act. And the choices it makes, or the people within it make, are greatly influenced by the circumstance and not always the law in the way that we in the legal profession like to think. And so looking through the legal process lens, how can we understand what that means? And so you've sat on Council for Relations and seen how little or much law influences thinking in that realm. And so, exactly, which brings me to the panel's question for each of you, and as an opportunity for you to ask each other and comment on each other's work. How do we remedy this imbalance that we have? How do we get towards a responsible government, particularly when we face national security, immigration, other matters that are not getting into the original intent and understanding, but yet people and politicians face real constraints on having to do something in today's world. And so I open it up to all of you to say something about what do you think responsible government should look like today, and how do you think in your respective realms we can inch towards that goal?
I mean, I would just say that I think that the Williams decision and what the High Court did in that decision was its response to the concern about how it's seen that responsible government operate in Australia. And what's really striking about the judgment itself is it goes through, well, Parliament hasn't been scrutinising spending through appropriations because we have really broad outcome-based appropriations in the annual budget. Parliament isn't even aware, there's no sort of database for executive spending programs. So you see the court actually worried about the practice of government in this Williams decision. And it's sort of then trying to balance, well, we can't be seen to be intervening and saying, well, these are the limits and we start enforcing these limits. And so it's sort of response and trying to be institutionally aware of its limitations is to say, well, Parliament's the one that needs to ask for more openness. Parliament's the one that needs to start flexing its muscles. It's got the muscles, so it's going to prod Parliament. And I think that that's a really interesting response. That was a 2012 decision. We just haven't seen it play out, so we don't know whether that prodding is going to work yet. The immediate reaction is, well, it hasn't worked in relation to spending because of this bizarre regulation-making authorisation, but it may be that they strike that down in the next National School Chaplains Challenge. We've had 2, why not 3? It could. I think we need to see how that plays out.
I think just to add to that, I mean, I think the court has in Australia at least a role to play, but one of the other challenges that we have is a bit like your cases and controversies. You need a person that has standing to challenge these things, and if a government is getting money for roads funding or something, a state government or a local council, they may well not challenge the regulations, and so I think that adds to the complexity of kind of, even in Australia, hoping the courts will do something to prod the legislature. Whether we can get that prod because we get that case in the first place may be a further challenge.
Well, I'd say I'm happy that in part the discussion centers on, or at least in Australia as well, at which Hal, I guess, first identified, which is, when the legislature is not living up to its role, then that's additional pressure on the court. And then, what happens when the court just basically says, we will stand up to the executive here, but we really need to invite the legislature to be the one to do it. And actually, not to be self-referential as opposed to reverential, but I end my book review to Hal's book by relating his work to Youngstown. Because it strikes me that the Williams case, when you were talking about it, it's very much struck me as Youngstown, in particular Justice Jackson. Now, usually when you first read about Youngstown or are taught it, you're taught that the Twilight Zone is roughly Jackson adopting the Frankfurter approach, which is, okay, at the zenith, Congress is approved, at the low ebb, Congress is disapproved. There's this twilight zone in the middle, and there's a persistent constitutional custom, then the president wins. And that's often read as, and the president should win. That's what Frankfurter says. What Jackson says is he qualifies his Twilight Zone language all over the place, saying, well, as a practical matter, Congress will win. I mean, the president will win if Congress doesn't step up. And then in the part not many people read, and by the way, this goes to the notion of is comparative law, does it have a place in constitutional interpretation? Jackson goes on this whole excursion into comparative law in the 1930s. And he talks about, gee, let's look at regimes where there has not been effective parliamentary check on executive power. This is the 30s, right? Germany, Italy, right? Let's look at regimes, where there has been, the United Kingdom. And so, the real way to read Youngstown is, and then this goes to, was it effective, it's really kind of this creed of prayer across the street saying, look, you guys, and not women so much yet, in Congress, play the constitutional role that was envisioned for you. And in fact, another thing Jackson does, anticipating Hal's work, is he then identifies all these other factors for why the president over time has gotten more power, the party system, foreign relations, et cetera. And when I was fumbling around on my computer is, the last lines, or 2 or 3 lines, this often doesn't make case books, but it is sobering, because we might ask ourselves to what extent has this call fallen on deaf ears, and I think the answer is mixed. I think, Congress often has let power slip through its fingers, but you do get these pushbacks like the War Powers Resolution. And sometimes my fear is more and more the courts aren't even getting involved, although sometimes, and I think what really happens is when the courts really don't believe or trust the president, then they'll push back. And I think that's the story of the post 9/11 cases. They just didn't buy the claims of the Bush administration. But let me just read, for those of you who might have not encountered it in a while, the last few lines of Jackson. He goes, with all its defects, delays, and inconveniences, men have discovered no techniques for long preserving free government except that the executive be made by law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, right? But it is the duty of the court to be the last, not the first, to give them up, which is, there's good news and bad news, right? So.
I learned yet another new term for Marty, self-reverential. I think there's too much of that in the legal academy already. I don't want to fall into that. Let me respond to all 3 of you as follows. Marty, when you started hearing about a nationhood power, you may have been thinking, doesn't that sound like what the federal executive branch sort of thinks like it has in foreign policy? And I'm very uncomfortable with that, say you, I want the courts to push back from it. Well, when I went over to Australia, I cautioned my Australian friends about allowing there to be too much unconstrained nationhood power. Dick Cheney would embrace the nationhood power. So they worried me endlessly. Of course, it was a failure of understanding and background on my part. What I had failed to see enough of was what I'll call a parliamentary paradox, or a parliamentary surprise. we knew that our president, through separation, has great power, independent of Congress. In a parliamentary system, after the Great Revolution in England in the 19th century, the executive is subject to control by Parliament. Everything's good. And then I started reading all the complaints in both British and Australian sources about the fact that the executive just dominates Parliament, and we just don't seem to have much control of it. So, as I got into that, I finally understood the promptings, I think, of your concern to have a greater judicial role. Because what both Gabrielle and Adam have talked about is getting the courts to push Parliament to control the executive. That's a different proposition, I think, Marty, than the one you're going to struggle with, which is to what extent should the courts say directly to the executive,
Right.
no, you can't do that.
Right.
You can't do that. So there's a mediating institution. It's calling Parliament to account for the role it's supposed to play. So I'm more comfy than I used to be.
We're relaying each other's concerns.
Yes.
Professor Post.
Well, a darker note, I was gonna, two questions. Darker one is, do you think, Gabrielle and Adam, that your story tees up a kind of convergence theory of executive power? It struck me, there are many details going on that I don't fully understand, but that you were describing situations of consciously very different institutional designs, nonetheless leading to American-style executive dominance, legislative fecklessness. And if there has been that convergence, notwithstanding the initial different designs, that might tell us something about the impotence of formal mechanisms here. And it sounds like, as here, legislative bodies in Australia are not well motivated to do the checking that all these conceptions of checking and balancing assume. Anyway, if you think convergence is teed up by your descriptive work, that might be fascinating to spell out. But and Marty, I just want to say briefly, I think there's maybe a tension in your project in the following sense. Why care if judges now do much less intervening on these international law questions than at the founding? One reason I take you to reject would be the originalist internal reason, just that that's not what the original understanding was, and stop. Therefore we should. But you don't want to rest on that. So then the obvious other thing to say, the more functional.
Actually, I might, but go
You
ahead.
might, okay. So the more functionalist thing to say is, well, the reason we want judges in there is to ensure the U.S. stays in tune with the international community and complies with its international obligations. The founders were very worried about that. That was the principle underlying their desire to have judicial involvement in the first place. But your very descriptive story of how the executive has become so dominant through the rise of these expert networks of regulators, the Anne-Marie Slaughter work, I think actually provides its own answer to that concern, in that the very kind of rise of these transnational networks that so deeply imbricates U.S. executive actors in the international community is also why the executive branch is less likely to get way out of step with international norms.
No, I'll push.
Okay,
Yeah,
all right.
second, I'll completely push back. First one, and the second one, the short answer is 2 words: extraordinary rendition. That's my soundbite, but I'll get back to that. Okay. The first one is this is where constitutional theory and the role of custom and a theory of custom ripening into legitimate constitutional law is critical, right? So, my baseline, this is why I say I may be, and I hate to quote Justice Scalia, a faint-hearted originalist myself, that one thing I am clear on based on previous work is while the founding generation disagreed immensely on the details of separation of powers, that if they agreed on anything, even far more than federalism at the time of the founding, it was this notion of separation of powers. It was the key diagnostic tool for what was going wrong in the states in the 1780s, and it was seen as the key solution. And in fact, one thing I'm doing is relating the story of greater national power to separation of powers. Historians have not seen a connection, and I see one, between the story of we need a much more powerful national government but how are we going to rein that, precisely because of our impotence in foreign affairs, how are we going to keep it under check? Separation of powers, for this, which is the same reason we can keep tyrannical majorities in check based on our domestic experience. So those two stories, so there's an incredibly powerful founding commitment to separation of powers. I'd say it is probably the most, if originalism yields you anything, it's that, okay? But that's not the only thing. There are all sorts of other sources of constitutional interpretation that I think yield a strong commitment to separation of powers, structural analysis, inferred political theory, et cetera, et cetera. Now, if you premise that there is a very strong commitment to separation of powers based on an array of interpretive methods, not just originalism, but especially originalism, then you're going to need a very powerful theory of custom overriding that. And I don't think that, in all but very few theories of custom would advocates of that come anywhere close, okay? So so it's not so much that, so there's that. Now, the second point, is international law. The problem, what the IR people are describing are interactions that may be customary, but are even more thinly customary, than the domestic actions that Hal's talking about. So they have even less of a claim to any sort of, constitutional legitimacy in their respective states. Quite the contrary, and this is where extraordinary rendition comes in, often they can become conscious ways to do end runs around established and recognized constitutional and legal checks. So I give you extraordinary rendition, right? When the United States picks up somebody in Italy, maybe with the complicity of Italian police, executive officials, maybe not, turns them over to Syria or Egypt with the obvious complicity of executive officials, say in Egypt, to have those people tortured, in contravention of both of the domestic laws of all these states as well as international law, that does not look like a source of legitimacy to me. That looks like a way to avoid legitimacy and accountability in the most fundamental ways imaginable. So now that's my dramatic soundbite example, but I think to a lesser extent that kind of phenomenon is occurring all over the place when you were talking about executives sharing information and empowering themselves at the expense of the courts or even of the legislatures.
And with no transition, I see that we
I'm sorry, you wanted to push back.
We are at time.
Yes, and I'm going to close it.
Yes, so please join me in thanking our panel.
Melissa deputed me to finish the proceedings. I am so glad she said this morning that she had to leave, so nobody will think that she simply marched out. For me, I do overflow with gratitude, you know that. And I think what I'm especially grateful for, along with all the accolades, is that I really did want this to start a conversation. It certainly has. The conversation spans oceans, after all, and will continue to do so. So I hope that conversation goes along and along. There will be a truly movable feast. And, well, let me borrow from the words of one of the most dangerous Americans who's ever lived to close these proceedings. Words uttered on the foredeck of the USS Missouri on a fall day, much like today, about 70 years ago, when General Douglas MacArthur stood up and proclaimed, "These proceedings are adjourned."